Hey everyone, it's Max here, and this is my new original story on the channel.
There is a sentence in the United States Supreme Court record that has never been struck down. It was written in 1927 by Oliver Wendell Holmes, one of the most celebrated jurists in American history. Holmes was 75 years old, had served on the Supreme Court for 26 years, and was regarded as a brilliant legal mind. He wrote the majority opinion in Buck v. Bell in a single afternoon. The opinion is 3 pages long. The sentence is, 3 generations of imbeciles are enough. It has been in the official record of the Supreme Court since May 2, 1927. Buck v. Bell has never been formally overturned. The legal precedent it established, that states have the constitutional authority to perform involuntary medical procedures on citizens they deem unfit for reproduction, has never been explicitly reversed. I want to tell you about Carrie Buck. Because Carrie Buck is not an abstraction. She is a specific person whose specific story was manipulated by specific people who knew exactly what they were doing. The manipulation is documented in records that have been in the Library of Virginia and the University of Virginia archives since the 1970s. Carrie Buck was born in Charlottesville, Virginia in 1906. Her mother, Emma, had been committed to the Virginia colony for epileptics and feebleminded in 1920. Carrie had been separated from her mother as a child and placed with a foster family named Dobbs. She attended school through 6th grade. The records show she was a normal student with nothing in them to suggest the intellectual disability that would later be attributed to her. Then, the Dobbs family removed her from school to work in their home as domestic labor. In 1923, Carrie was 17 years old. She became pregnant as the result of an assault by a member of the Dobbs household. The Dobbs family had her committed to the Virginia colony in January 1924. The stated reason was moral and intellectual unfitness. The actual reason, documented in correspondence between Colony Superintendent Albert Priddy and the Dobbs family, now held in the University of Virginia archives, was to protect the family from the consequences of what had happened. Carrie Buck was not what they said she was. She was a young woman whose foster family used a state institution to silence her. Albert Priddy had been looking for a test case. Virginia had passed a law in 1924 authorizing involuntary procedures on institutionalized people deemed unfit, and Priddy wanted to establish its constitutionality through a legal challenge he expected to win. Carrie, with her institutionalized mother and her infant child, was his chosen subject. He selected her deliberately. The correspondence documenting this selection is in the University of Virginia archives. The letters between Priddy and the eugenics movement's legal architects, including Harry Laughlin of the Eugenics Record Office, who would later receive an honorary degree from a German university for his contributions to eugenics law, describe the strategy for choosing a test case and the specific reasons Carrie was selected. Laughlin's honorary degree from Heidelberg University is documented. It was awarded in 1936. 3 years later, the German government was operating programs modeled on the American statutes he had helped draft. The case reached the Supreme Court. Carrie's court-appointed attorney was a friend of Priddy's and a supporter of the eugenics program. The trial record, which is in the Library of Virginia, shows almost no cross-examination of the program's witnesses, no evidence presented that Carrie was other than what they claimed, no challenge to the institutional commitment that had created the case. The Supreme Court ruled 8-1 in favor of the state. A law professor named Paul Lombardo began investigating the case in the 1970s. What he found in the archives was specific. Carrie Buck had not been what the court was told she was. Her daughter Vivian, the third generation referenced in Holmes's phrase, was described by her first-grade teacher as bright and perfectly normal before the child died of illness at the age of 8. The case had been constructed to reach a predetermined outcome. Lombardo published his findings in academic journals in the 1980s. The records he worked from are still in the Library of Virginia and the University of Virginia archives. Anyone can request them. The Supreme Court's opinion stands. It has never been reversed. Now I want to tell you about the 33 states, because the 33 states are where the story stops being about Carrie Buck and starts being about you. Between 1907, when Indiana passed the first state law of this kind, and 1963, when the last state eugenics board formally disbanded, 33 American states enacted laws permitting involuntary procedures on people deemed unfit for reproduction. The criteria varied. Some focused on intellectual disability. Some included epilepsy. Some included what they called hereditary criminality. Some included sexual nonconformity. The 33 states are documented in the legislative record. The laws are in state session laws. Some were repealed. Some were allowed to expire. Some have never been formally removed from the books. The records of Virginia's program are in the Library of Virginia. Approximately 8,300 Virginians were affected between 1924 and 1979. The records include each person's name, their institutional file, the stated justification, and the authorization paperwork. Not 1927. The North Carolina records are in the State Archives of North Carolina in Raleigh, partially unsealed in 2003. North Carolina's program ran from 1929 to 1974, approximately 7,600 people. The records document a significant shift in who was targeted in the 1950s and 1960s, when black women became disproportionately represented in the authorization orders. North Carolina established a compensation program in 2013, the first state to do so, paying living survivors $20,000 each. The program's terms are in North Carolina legislative records. California's program affected more people than any other state, approximately 20,000 between 1909 and 1963. Those records are in the California State Archives. And then there is what happened in California between 2006 and 2010. The California Department of Corrections authorized procedures on 144 incarcerated women during that period. A state audit completed in 2013 found that the consent process was inadequate. In some cases, women were asked to sign consent forms while in active labor. The audit report is a public document, California State Auditor Report 2013-119. It names the facilities. It describes the procedures. It documents what happened. The audit was published in 2014. The procedures happened between 2006 and 2010, not 1927, 2010. On December 9, 1946, the Nuremberg medical trial began. 23 defendants, German physicians and Nazi officials, were charged with war crimes and crimes against humanity for their roles in medical experiments conducted in concentration camps and in the mass sterilization programs conducted under the Law for the Prevention of Hereditarily Diseased Offspring, passed by the German government in July 1933. The German sterilization law of 1933 was modeled explicitly on the model eugenical sterilization law drafted by Harry Laughlin of the Eugenics Record Office in Cold Spring Harbor, New York. Laughlin had published the model law in 1922. The German statute adopted its structure, its categories of hereditary disease, and its procedural mechanisms from Laughlin's template. The Nazi defendants at Nuremberg knew this. Several of them cited it. Karl Brandt, Hitler's personal physician and one of the primary architects of the Nazi medical program, testified that German sterilization policy had been developed in explicit reference to American precedents. He cited Buck versus Bell by name. He cited the California sterilization program by name. He argued that Germany had followed the legal and scientific standards established by the United States. Brandt's testimony is in the Nuremberg medical trial record. The record is in the National Archives under Record Group 238. It has been there since 1947. The specific citations to American law are in it. He was convicted and executed in 1948. The American law he cited, Buck versus Bell, was not repealed or overturned after his execution. It remains valid precedent today. I want to be specific about what valid precedent means and does not mean, because this is the point where the story is sometimes overstated, and I want to give you the accurate version. Buck versus Bell has never been formally overturned by the Supreme Court. No subsequent Supreme Court decision has explicitly stated that Buck v. Bell is no longer valid law. The case has been largely ignored rather than reversed, mentioned in later decisions as an embarrassment, but not formally addressed. In 1942, in Skinner v. Oklahoma, the Supreme Court struck down an Oklahoma law that sterilized repeat criminals, but on a different legal basis, equal protection, rather than by reversing Buck v. Bell. Justice William O. Douglas wrote for the majority in Skinner that he was not overruling Buck v. Bell, but was deciding on different grounds. The practical effect is that the specific holding of Buck v. Bell that states can sterilize people deemed unfit has never been directly and explicitly struck down. Legal scholars disagree about what this means in practice. Some argue that subsequent doctrinal development in reproductive rights law, including Griswold v. Connecticut in 1965 and Roe v. Wade in 1973, has effectively overruled Buck v. Bell even without explicitly doing so. Others argue that the holding remains technically valid and could theoretically be invoked. What is not disputed is that the sterilization programs continued long after anyone should have felt comfortable with them, that they were applied disproportionately to poor people, black people, Native Americans, and incarcerated women, and that the records documenting who was sterilized are in state and federal archives across the country. Now I want to tell you about the Indian Health Service records, because the IHS sterilization program is the one that is most systematically under-discussed and most systematically documented. Between approximately 1970 and 1976, the Indian Health Service sterilized a significant portion of Native American women served by the agency's facilities. The estimates vary. A Government Accountability Office report published in 1976 documented 3,406 sterilizations in 4 IHS service areas between 1973 and 1976. Native American organizations in the 1970s estimated the total number of sterilizations across all IHS facilities in that period at between 25,000 and 50,000. The GAO report is a public document. It has been available since 1976. It is titled Investigation of Allegations Concerning Indian Health Service and was published on November 4, 1976. It documents specific facilities, specific numbers, and specific procedural problems with the consent process, including consent forms given to women in labor, consent forms in English given to women who spoke only their native language, and hysterectomies performed on women under the age of 21, despite a federal regulation prohibiting sterilization of minors. The Indian Health Service records from this period are in the National Archives. The consent form problems documented in the GAO report are in the IHS correspondence files. The women who were sterilized by the IHS in the 1970s were not reached by a 19th century eugenics law. They were reached by a federal agency operating in the 1970s, with federal consent procedures that were inadequate in communities that had limited access to independent legal advice by physicians who operated without meaningful oversight. The 1970s, with federal funding. The GAO report documenting this has been in the public record since 1976. Now I want to tell you about the records that can tell you if your family was affected, because this is not history that happened to other people's families. It happened to specific families in specific places, and the records that document it are organized by name and by institution. The Virginia eugenics records are at the Library of Virginia in Richmond. The collection includes institutional files from the Virginia Colony for Epileptics and Feebleminded and from Western State Hospital. The files are organized by individual. They include the person's name, the stated reason for the sterilization recommendation, the authorization chain, and in some cases, correspondence with family members. If your family has roots in Virginia and had a relative institutionalized between 1924 and 1979, the Library of Virginia may have their file. The North Carolina records are at the State Archives of North Carolina in Raleigh. They are partially restricted, but partially accessible. The finding aid describes what is available and what requires a request for access. The California records are at the California State Archives in Sacramento. The collection includes records from Sonoma State Home, Patton State Hospital, and other institutions. These are not hidden archives. They are in state archives that issue finding aids and respond to researcher requests. The records have names in them. The names belong to people who were failed by the legal and institutional system that was supposed to protect them. Some of those people are still alive. Some have grandchildren who do not know what happened. The records have been in the archives since the programs ended. Carrie Buck lived until 1983. She was never told by anyone with authority that what had been done to her was wrong. She spent the last years of her life in a nursing home in Waynesboro, Virginia. A journalist who visited her there found a woman who was not feeble-minded, who could hold a conversation, who had lived a full human life, despite what the Virginia colony and the Supreme Court of the United States had decided about her. She died on January 28, 1983. Buck versus Bell was still valid precedent the day she died. It is still valid precedent today. The opinion is in the Supreme Court record. Holmes's sentence is in it. The word imbeciles is in it. The 8-1 vote is in it. It has never been struck down. The Buck versus Bell. Supreme Court opinion is publicly available through the Supreme Court's website and through any legal database. The citation is 274 U.S. 200, 1927. The full text of Holmes's opinion, including the sentence, "3 generations of imbeciles are enough," is in it. The Virginia eugenics records are at the Library of Virginia, 800 East Broad Street, Richmond, Virginia. The finding aid is available through their website. Researchers can request access to institutional files by name. The North Carolina Eugenics Board records are at the State Archives of North Carolina in Raleigh. The collection is described in the finding aid available through their website. Some records require formal access requests. The California State Archives in Sacramento holds the records from California's eugenics institutions. The finding aid is available through their website. The GAO report on Indian Health Service sterilizations, investigation of allegations concerning Indian Health Service, November 4, 1976, is available through the GAO's Historical Reports database online. The Nuremberg medical trial records, including Karl Brandt's testimony citing American sterilization laws, are in the National Archives under Record Group 238. The trial records are also available through the Harvard Law Library's Nuremberg Trials Project online. Paul Lombardo's research on Carrie Buck, the scholarship that first documented the manipulation of her case, is collected in his book 3 Generations, No Imbeciles, published by Johns Hopkins University Press. His original academic articles from the 1980s are available through academic databases. The law may still be on your state's books. The records of who it was used on are in the archives. Subscribe, because next week we open another file.